Yes.
Before the short adjournment, I've just been finishing on paragraph 106 of Prudential High Court, page 755, in the authorities, and I've made the reference to the observation that whether the obligation of removing the incompatibility with EU law, whether that was discharged by a process of conforming interpretation or disapplication, ought in principle to make no difference. And in the context of that case and the type of claim that was before the court at that stage, it didn't make any difference. That was a point which was reiterated, as it happens, in the Court of Appeal. I mean, Your Lordship's hands whether you want to look at this. It's paragraph 77.
Briefly.
I'll just show you the passage. It's paragraph 77. It's electronic page 879. I fear that's in a different volume. It's tab 34, which should be in volume 3.
Yeah.
And this just records the status of the argument on disapplication versus conforming interpretation at that stage. It's page 879 by the letter H. And you can see the position at that stage. In practice, we can see little difference in this case between a partial disapplication and a conforming interpretation. But that, of course, isn't the position here. What I'm saying is that when one's looking at the conforming interpretation in these cases, one has to look in more detail at the procedural steps, and one has to take into account the fact that on the, if you like, vanilla application of the conforming interpretation that was set out in Prudential, what the Upper Tribunal is saying in effect is, well, these taxpayers, they're taken by surprise. That's too bad. And my submission is that that isn't a permissible result. And it's not an answer in my submission to say, well, the conforming interpretation is settled by Prudential and we just apply the declaratory theory, that's the end of it. That wouldn't be right. One has to have regard to the relevant EU principles, including but not limited to effectiveness. Effective legal protection is another one, legal certainty that one has to have regard to. And one can see this in action actually in FII Court of Appeal in 2010. And can I just show you this? It's actually developing a bit more of what was said about issue 6. So this is back in volume 2, authorities, tab 27. And fully accept that the context of this is different. This is about ACT. It's just the principle that I'm interested in at this stage, and the different stages in which these principles may come into shape and come into play. Issue 6 in the Court of Appeal starts at electronic page 529 in the authorities. And the nature of the breach doesn't really matter.
Yeah, we looked at 97 earlier. Yeah.
Yeah, 97. We looked at 97, and I hope this helps in answering one of the questions that Lady Justice Falk put to me before the short adjournment. So they're looking at the competing conforming interpretations as the Court of Appeal in this case saw them. You can see what they were in paragraph 100, page 530. And then paragraph 101, some reliance had been placed in the High Court on saying that that interpretation would circumvent some of the practical difficulties claimants would encounter in proving their claims, thus avoiding a possible breach of the community law principle of effectiveness, and then the points made in 102, well, that approach is liable to confer a windfall. And then the nature of the principle of effectiveness is summarised in 103. And we all know mustn't render virtually impossible or excessively difficult the exercise of a right to repayment. And that may result in rules of domestic law, whether it's adjectival law or substantive law, being set aside to ensure rights conferred by community law are effective. And then you can see the particular concern being identified in paragraph 104. It's the inability to trace and look more widely within the group. That was a particular complexity that arose in the context of the ACT claims. And then paragraph 105, effectiveness, that didn't affect the interpretation of a statute in circumstances such as arise in the present case. So there the court's just looking at 231. They say there isn't any further test about ease of enforcing, and retrospective claims aren't inevitably difficult to enforce. And then 106 is important. Can I just ask the court please to read that, because that shows in my submission that the court leaves open the possibility that the principle of effectiveness may come into play actually at a later stage. And that's even after this conforming interpretation is established in this particular case. And then in 107, and 107 is one of the paragraphs where this court made corrections to the judgment which is reported in Simon's tax cases, which is why one can't with any confidence use the Simon's tax cases report. There were some amendments which included paragraph 107. But you can see that the conforming interpretation is set out, and then 3 lines from the bottom of 531, the extent of that entitlement can then be investigated when the sections fall to be applied. Difficulties more properly arising at the point of application should not be erected as an objection to conforming interpretation.
So when you say there's an error in the STC version, we're looking at the original judgment here, are we?
So what happened, and this
Okay,
is...
I don't need the details,
no,
but what we're looking at here is the original.
2 judgments were given. The judgment was withdrawn and a new judgment is issued. Simon's tax cases reported the first judgment, and the amended judgment has, to my knowledge, never been reported. Which is why that's the version that this court has as the correct one. I think it's got a date of March 2010 on it. The absence of a report is something that's caused problems every time that cases like this have been argued, unfortunately. The reason I'm taking you to those passages, fully accepting they're talking about ACT, that you can see the principle that they weren't at that stage going to look more closely at effectiveness. But you can see the door is open, if need be, at a later stage to doing exactly that. And that might have required some different approach to be taken, either in relation to construing the legislation or as they note in paragraph 103 in relation to setting aside provisions either of substantive law or of adjectival law, evidence of procedure. So this is a very important aspect of my complaint as to where the Upper Tribunal went wrong, because what the Upper Tribunal has done in my submission is take a conforming interpretation, identified in a case in which the difference between either one conforming interpretation and another, or a conforming interpretation and disapplication, it made no difference in Prudential. And they've proceeded on the basis that the UK provisions, they've simply been retroactively made to comply, and you simply apply the system on the basis that there's never been any breach. And there's been no account taken of the fact that what one needs to do is to arrive at a conforming interpretation, giving effect to the EU law rights of these taxpayers, which includes the rights they have under general principles of law.
forgive me, it may be my misunderstanding, but that seems to me to be jumbling up a number of different points. The first question is how the legislation should be interpreted consistently with EU law. That's done by conforming interpretation, and that is now settled. Then one comes, that is now settled. The conforming interpretation is now settled. Then there is a second question as to application of the legislation to the facts. Now, what the Court of Appeal has made clear in this passage, it seems to me, is that there may be questions of the application of the EU law principle of effectiveness which arise when a claim is made, even after a conforming interpretation has been adopted. And so they talk about, for example, by way of illustration, ameliorating the evidential difficulties. However, that doesn't mean to say that that's a question of statutory interpretation. There is only one interpretation of the statute, and that's the conforming interpretation, and it is retrospective. All the Court of Appeal is saying here, as it seems to me at the moment, is that's not necessarily exhaustive of all issues that may arise.
And that way of looking at the matter, in my respectful submission, it doesn't hurt me, because what one would need to do is look at these claims that have been made in the light of the conforming interpretation and taking account of the wider general principles of law. So I don't have a difficulty with there being one interpretation of the statute. What we're dealing with is can that interpretation be applied so as to knock out claims that ostensibly appeared to be valid on the terms of the legislation as originally set out.
All right.
And I'm not saying that FI Court of aha, there's the answer. All I'm putting it forward as is an illustration of the salience of general principles even after the conforming interpretation has been looked at by the court.
Are you saying a kind of second round of, so to speak, ancillary conforming interpretation might have to come in at
Potentially,
this stage?
Yes.
It becomes a kind of endless process, doesn't it? Once one's sorted out what the legislation means on a conforming interpretation, then on a conventional view, you then look at the facts and apply one to the other.
Not endless. I mean, hypothesize this case. Suppose, Your Lordship, when it came to trying the Prudential claims, suppose it hadn't been a common law restitution claim. Suppose it had been a statutory claim. It had been a para 51 claim. Prudential, as it happens, and we know, and the FTT in this case has found, their statutory claims were paragraph 51 claims. Suppose it was those claims that were being adjudicated upon by Your Lordship. One of the issues that would have had to have been dealt with in the light of the conforming interpretation is, well, what is the impact on that of these claims? Have Prudential actually brought valid paragraph 51 claims or not? And that's something that would have needed to have been grappled with. What's happening in this case, and in a way that this really is my complaint, one is taking a conforming interpretation that's been developed in a case where the difference didn't make any difference because it was common law restitution claims and it's common ground essentially, that to the extent that the tax charge is unlawful, the common law claim works. And it's now being said, oh, well, aha, that's fixed, there's nothing else to see, and the music has now stopped, and I'm terribly sorry, Mr. Bremner, your clients have been left without a chair when the music stopped. And that's not, in my submission, either an appropriate way of giving effect to EU law rights, and it's not consistent with the general principles, which I'm going to show the court in fairly short order this afternoon. I don't accept that it would make it an endless process. One's simply asking, of these particular taxpayers, is there effective legal protection of their San Giorgio right? And is there also compliance with the principle of legal certainty if one is going to conclude that the claims that they brought in good faith, reasonably on the basis of the legislation as they thought it to be in, say, 2009, if we stick with the case of Standard Life, if one's going to say that that claim, in fact, was of no effect at all.
But they always had the option of bringing a restitution claim.
My lord, one only knows that with the hindsight that's given by the Supreme Court's judgment in 2012.
Well, is that completely fair? Because the evidence you referred us to earlier, my understanding of that evidence, correct me if I'm wrong, is essentially that these claimants didn't join the GLOW earlier because of the costs.
And that's certainly what Ms. Smith and
That was their evidence.
but
Not because, oh, we just don't think the GLOW would provide us with a remedy.
No, I mean that's fair. There are passages in the statements that say that. That's right. But what I'm making is a more general and objective point, because this can't turn on the subjective motivation.
No, of course, but
claimant.
I'm raising it because you effectively raised the contrary position earlier and said, oh, at this stage, people thought that the statutory remedy was the correct one.
But what I'm saying, one has to look at all the facts and circumstances. The point I'm making is that, yes, it's right that we know that a pre-1 April 2010 High Court claim has turned out to be a valid route. We know that from 2012 onwards, following Supreme Court 1. What I'm saying is that was not known as at 2009. There might be all sorts of
But
reasons.
why is that different to any case where a litigant has alternative claims and he chooses, e.g. for cost reasons, to bring one claim? Unfortunately for him, it turns out it fails. And with benefit of subsequent knowledge, it becomes clear that the alternative claim would have been the better claim to bring. But by the time that becomes clear to him, it's too late.
Well, Mara, it's different because the reason that is happening is because of the retroactive nature of the conforming interpretation, and there are three cases in particular that I want to show the court, which are Gil San Juan, Bele, Viciano.
Right. Okay. Let's get on to those then.
Can I just check? I don't need to do anything else on Prudential before I do that. And can I just also then make one point about the further respect in which the UK provisions are in breach? I just want to finish my account of breach, and then I promise that those three cases will come in short order thereafter. Can I do the last point, which is on FI Supreme Court 3, which is 2021, quite shortly? I just wanted to deal with it briefly in my chapter on what the breach was, because what it shows, and I don't think we need to turn this up, I can show you this when I do issue 10, which is the issue that it most directly refers to. FI Supreme Court 3, which is Authorities Volume 4, tab 48, page 1316, that shows a further manner in which the UK provisions breached EU law, and some of the history of this was argued out in front of my Lady Justice Falk in the AXA case. So this may well be old ground, but this was all to do with the fact that because of set-off of group relief and management expenses, they'll actually reduce taxable profits. And what it meant was that there was, on any view, additional taxation relief that was lost. And what had happened was that there was a case in the European Court of Justice called Salonen, which essentially said that you couldn't have a situation, this was in Austria, where losses applied to reduce taxable profits, and then the absence of double taxation relief meant in a later year that there was an additional tax charge over and above what would have been the case if the dividend income had been exempt. And what what the Supreme Court tells us, and this is paragraphs 144, 145, and also 158 in FI Supreme Court 3, is that there is this further breach of EU law. It's over and above the absence of the credit for tax paid for portfolio dividends, over and above the absence of credit at the nominal rate. The UK provisions breach EU law in that they do not permit double taxation relief to be carried forward in circumstances where management expenses or group relief, it's management expenses which are relevant for us in so far as those items use up taxable profits and the DTR is then unable to be carried forward. And to the extent that tax is paid, there is a San Giorgio claim for its repayment. I wasn't proposing to show you the detail of that now, but that is very relevant when we get on to issue 10. So that, if you like, is a third respect in which the UK provisions breach EU law. So that's what I wanted to say, and I'm sorry that it's a sort of longer than usual account of the background, but the journey here is very important, and it frames then what I'll be about to say. I've got now to what we call ground one, which is validity of the claims made before the establishment of the conforming interpretation. And really there are two aspects to this question, as I said up front. One is whether overriding principles require the taxpayer's claims to be accepted. And the second is, even if those principles aren't engaged, are the claims in any event valid claims under domestic law? As we say in the skeleton at paragraph 16, that the first tier, they accepted the overriding principles upon which I relied. That was 68 to 89, where they're set out. They didn't need to apply those principles because when you see Judge Brooks's decision, he finds on each of the issues for the taxpayers essentially just applying domestic law. The Upper Tribunal also set out the overriding principles. There's no real quarrel about them, and I don't really understand in this court to be any great quarrel about what the principles are. What the Upper Tribunal said, and this is the conclusion that Learned Friend supports, they say, well, they're just irrelevant. The overriding principles don't change the answer that they'd come to that the taxpayers' claims were invalid under domestic law. What I was proposing to do is to deal with the overriding principles sort of first and separately, and then turn to the domestic law requirements issue by issue, and that was more just a matter of convenience than anything else. I suppose strictly what I should really be doing, but I'm worried that I'd descend too far into the minutiae, is look at each issue, at each claim, look at every aspect of domestic law. Only once I've lost on domestic law, then look at what I say the overriding principles does. What I'm going to do, of course, is when I look at the specific facts, I'm going to deal with both the domestic and then what the overriding principles do. Can I just deal with one sort of general point about the UK statutory regime? And this is looking at claims for double taxation relief generally. One of the things that is striking is the very limited nature of the formal requirements that apply in relation to such a claim. So there's no prescribed form. There's no requirement that the claim must say that it's for credits or that the claim must mention section 790. The Upper Tribunal accepted, and indeed this was common ground, that labels are not determinative. That was its paragraph 103. The statutory requirement is that the claim must be quantified. That's paragraph 54 of Schedule 18. But it's common ground that that requirement is met in all of those cases. All that it means is that the claim must include a figure. There's no requirement that the figure be accurate.
Wait, sorry, just going back to one small point.
Yes.
At the risk of descending into the minutiae, as you refer to it, but we'll come back to it if necessary. As I read the legislation at the time, you needed to claim the credit because otherwise the default was a Section 811 deduction. Section 811 is in mandatory terms, but is subject to 7952, which is actually the gross up provision.
Yeah.
So you don't need to deal with it now. I don't want you to take you out of your course, but one of the questions I've got when we get to the detail relates to that. My reading of the domestic legislation is you needed to claim a credit because otherwise you effectively default into the deduction.
I'll come back
Thank
to
you.
that if yes. And I suppose just the other observation just to make while we're on the domestic legislation is 793 sub 1 functionally what the credit does. This is page 48 in the authorities. Where credit's allowed, what happens is that the amount of the United Kingdom taxes so chargeable shall be reduced by the amount of credit. That's just
Is there anywhere a provision which actually says in terms that DTR credit has to be the subject of a claim?
so. Let
There
me.
are provisions which assume that, but oddly enough, I can't find anyone that actually spells it out.
It is a matter of assumption rather than
It seems
rather
very
than
odd, something so fundamental to be,
requirement.
to be assumed.
Okay.
Is it fair to say the closest is 7886,
Yes, it is.
Yeah.
And
which is effectively incorporated into 790 because you're deemed to have
because you
arrangements?
have to pretend that you've got arrangements containing sub whatever it is 4 to 10.
But it isn't I mean, I think it's clearer in the rewritten.
It's clear in the new legislation, but we're not under the
No,
new
I know.
legislation for any of these. And I'm terribly sorry, I can't remember who said 788 sub 6 to me, but it's quite right. So 788 sub 6 assumes that a claim is to be made.
Yeah, and
It's only-
otherwise the time limit.
and 806.1 and there are the other provisions in 806 on the time limit assume that there needed to have been a claim.
Yeah.
So that's how it's done. That's right.
Yep, thank you.
So can I deal, please? Now, I'll try and do this quite shortly because the real question here is not so much what are these general principles, it's do they have any resonance for a case like this? And that was why the approach I'd taken was very much to focus on three examples from the case of Gil San Juan, Belle and Viciano. Can I just try and give at least a partial answer to my Lord Justice Arnold's question for this morning about why we're even looking at this material in a post Brexit?
No.
Oh.
No. That question was specifically about the charter.
I'm very sorry. The partial answer, I'd like to look a little bit further
And yeah,
at the status
once-
of the charter.
because without getting into too much detail, I'm not sure we need worry about ruler for the reason you gave this morning. But the charter goes out under the 2018 Act.
It does, yeah.
And so even before you get to ruler, the charter is out. And we have to bear in mind what was said in City Flyer in the Supreme Court.
Can I
So-
ask, I think the abbreviation, Your Lordship, means the 2023 Act. I think.
Yes.
I just couldn't.
Yes,
Yes.
commonly known as ruler.
Can I come back to Your Lordship in the morning just on the status of the Charter specifically? But the reason we don't need to worry about the Charter in my submission is that the principles that we are talking about, they reflect general principles of EU law, and you can see that recorded in the First-tier's decision in paragraph 74. So what I'm not doing is relying on anything that the Charter alone gives. And looking at the 2023 Act, we know, of course, I'm sure your Lordship's familiar with this, Section 3 turning off supremacy from the end or from after the end of 2023. Section 4 switching off general principles from after the end of 2023, but importantly, Section 22 sub 5, Sections 3 and 4 and also Section 2, they're said not to apply in relation to anything occurring before the end of 2023. So I get into this through the general principles of union law. It so happens that one of the particular general principles we're talking about is also set out in the Charter. But the Charter isn't doing anything that's not already there in the general principles of union law. And those general principles, they have been informed by the Strasbourg case law, and there's been no dispute, and the first tier explains this in paragraph 76 in its decision, that the level of protection in EU law, that has to be at least equal to the protection under the ECHR. But the difference is that the ambit of the protection in EU law, that's broader. And in particular, EU law is not restricted to civil rights and obligations. So the fact that we're dealing with a tax dispute doesn't make Strasbourg authorities irrelevant. So that's why it is, I say, we're able to look at these principles on any view. It's because these are general principles of union law, and I'm particularly relying on effective judicial protection, effectiveness insofar as that's doing anything different, and legal certainty. And the three examples that I say are instructive for the purposes of this case are, first of all, Gil San Juan, which is in Authorities Volume 6, and it's the penultimate tab 69, starting at page 2045. And if the court has bundled page 2047,
So I did hear, and I believe understand what you said earlier, but you need to be clear about this. This is a Strasbourg judgment dated 26th May 2020.
Yep.
So are you telling us that this judgment has been applied by the Court of Justice in any case prior to the 31st of December 2020? Seems unlikely.
I'm not saying that.
Right. So how does it come in?
Because I say that this is simply an example of principles recognised at an earlier stage by the Court of Justice in its case law.
How can that be right? It's a later decision of the Strasbourg Court. On its face, this has got nothing to do with EU law at all. This is convention rights.
Yes. But
and you're not relying upon your convention rights, you're relying upon your EU law rights.
Yes, my lord, I am. But one of those EU law rights, and this was why I asked your lordship to look at what was said in 70.
But if you've got an EU law principle, yes, you must have a Court of Justice judgment which establishes that principle.
Yes, and my lord, and the Court of Justice judgments are largely the ones set out, in fact, in the FTT decision and also in Viciano.
Right.
The reason I'm giving your lordship or asking the court to look at this case is simply as an example on the facts of how far these principles can go. There's not a new
But
principle that's
But what you have not articulated to me yet is any basis upon which we can have regard to this jurisprudence. Because, as we've established, it's not a decision of the Court of Justice, it's a decision of Strasbourg. You're not relying upon your convention rights, and you're not relying upon any subsequent Court of Justice judgment applying the reasoning in this judgment. So how can we look at it?
My lord, what I'm saying and this is sort of, if you have the first tier's decision, because I don't think I have the explanation. The explanation document. I mean, maybe that I'll need to produce this tomorrow to answer your question properly. But in the FTT decisions, core bundle page 280 is the start of this discussion of the principles. And as I say, there's never been any dispute that these cases can be looked at. The dispute has always been, do they actually have any relevance to circumstances of this nature? What I'm relying on is the EU law principle of effective judicial protection, and that's in the treaty. And we do have that in the bundle. Article 19 sub 1, authorities page 218. And that principle, it originates not in the Charter, but in the general principles of union law. That's as the FTT records at paragraph 70, and there's no dispute about that. And they refer to Article 19 as one of them. What the Charter does, and this is why, as I say, in my submission, it doesn't matter whether the Charter is turned off without the possibility of looking at it again as part of the Brexit process. What the Charter does is it brings together fundamental rights protected in a single document, and they include the right to an effective remedy. But that is just an aspect of the principle of effective judicial protection, which doesn't, as the FTT rightly says, doesn't originate with the Charter, but which is implemented through general
Exactly.
principles.
This is why I don't understand why you need to be sidetracking us with authorities of doubtful relevance. Because, as I understand your case, actually you don't rely on the Charter. What you rely upon is pre-existing principles of EU law.
Oh, that's right.
So we can take those from the pre-existing case law of the Court of Justice.
My lord, you can. What I'm offering, the reason I'm offering you Gil San Juan and Bele is because they are particularly striking examples of retrospective changes to procedural requirements. So they're not doing anything new.
But they're not binding on us.
Accept
So-
that they're say, well,
But they would be if you were invoking your convention rights, but you're not.
well, save insofar as they're coextensive with the existing EU law principle. It would be one thing if Gil San Juan or Bele were recognising some new principle, but these are just examples of the existing principle in my submission.
All right, well, let's see where we go. But at the moment, I'm not persuaded that this is something that we can properly have regard to. But let's have a look. De
Can I-
Bene essay.
Can I? I'm very grateful, and I'll come back to the admissibility point. Gil San Juan, you can see the summary of what was going on in the paragraph under introduction on page 2047. So there'd been an appeal, it had been declared inadmissible because there'd been a failure to comply with certain formal requirements. And no opportunity given to amend. And
Yeah, so there's a breach of the applicant's convention rights, Article 6.1
that's right.
of the convention.
And you can see the applicant's argument in paragraph 9 at 2049. And the complaint is accepted. I'll pass over the submissions. It's particularly in paragraph 31, page 2058. And one can see that a situation of excessive formalism that can run counter to the requirement of securing a practical and effective right of access to the court. And the distinction, reading on in paragraph 31, is particularly by reference to issues of legal certainty and proper administration of justice, and where the court sees the line between non-excessive and excessive formalism is where the rules cease to serve the ends of legal certainty and proper administration of justice and form a sort of barrier preventing the litigant from having his or her case determined on the merits.
So that gives rise to this question. Is the doctrine of excessive formalism part of the case law of the Court of Justice? Because if it is, this adds nothing, and if it's not, it's illegitimate.
So excessive formalism is certainly a principle that is referred to by the Court of Justice. One example of that is the Mylica.
Right, so why can't we take it from that?
I suppose the court can, but Mylica is in a very different factual context. The factual context of this case, in my submission, is actually on analysis close to what has happened here, because the applicant in Gil San Juan, she brought a appeal using the procedure as it appeared to be available to her under national law. There was then a judicial decision of the Spanish top court, a higher court, saying it's something else. That was applied retroactively. Her appeal was declared inadmissible. That's a breach.
I mean, here you do have a practical and effective right of access to a court by virtue of choosing, as you could have done, to bring a restitution claim.
Well, my lord, not in circumstances where the availability of that claim, if one looks, say, at Standard Life's case, as at 2009, the availability of that claim is uncertain. That's the point.
Well, it may have been uncertain then, but it's been rendered certain by subsequent authorities.
Lord, I understand that, but that doesn't mean, and the Upper Tribunal in my submission was right about this, because they rejected Milner Friend's reliance on the availability of a common law claim. They said, well, that's not an answer. You've got to, the taxpayers are entitled, if statutory remedies appear to be available, to use those statutory remedies. If and then they said that the particular routes that had been chosen weren't the right routes.
All right, but at the moment you're trying to educate us as to principles of EU law
Yes.
by reference to a decision of the Court of Human Rights saying nothing about EU law in May 2020. So you've taken us to 31. What else is of assistance to us?
And can I show you the conclusion on the facts of that case in paragraph 44?
Sorry, why is it legitimate to have regard to a decision of a court on facts of the case?
Well, I'm simply
we look at authorities for the principles
understand.
they establish, not for the factual results.
Perhaps I didn't put it very well, my lord, but what I'm trying to do by showing you this case is to illustrate for your lordship the breadth and the rigour of the principle of effective judicial protection. That's what I'm trying to do.
So we've got the statement of principle in paragraph 31. Is there any other statement of principle which you say is of assistance?
I was going to show you paragraph 44. And picking up legal principles, what I'm saying is that this is an illustration of actually longer established principles which are recognised by the Court of Justice, and you can see that, for example, in the citations from the Banco de Portugal case, which is a Court of Justice case set out by the First-tier Tribunal in the core bundle at page 283. And it's in its decision paragraphs 80, quite extensive quotation from it up to 82.
Sorry, FTT 283.
It's core page 283, and it's paragraph 80. I draw to your lordship's attention, and these are principles set out by the court. This is 82, by reference to its settled case law. We need rules of law to be clear and precise, and their application must be foreseeable for those subject to the law. And going on, that legislation must enable those concerned to know precisely the extent of the obligations imposed on them, and those persons must be able to ascertain unequivocally their rights and obligations and take steps accordingly. And 53 and 54 deal more with the facts in that case, but going back to principles, paragraph 57 is quoted halfway down page 284. The effectiveness of the judicial review guaranteed by the first paragraph of Article 47, of course that's the Charter, but that is just the embodiment of the principle of effective judicial protection. That requires that the person concerned is able to defend his or her rights in the best possible conditions and to decide in full knowledge of the facts whether it be useful, in that case, to bring an action against a given entity. And you can see in the Portugal case what had happened in paragraph 63. What had happened was there'd been a retroactive change in law, and that affected
in national law.
In national law, yes. Retroactive change in national law, which affected the entity against which the action needed to be brought.
The case against you on this point is there's been no retroactive change in national law. The
Yes, and
rules are all set out clearly.
yeah, and my answer to that is that can't possibly be right, because there is a retroactive change to national law, a requirement, an entitlement to a credit is being read retroactively into section 790, and retroactively a requirement to claim such a credit is being drawn out of section 790. So these absolutely are retroactive changes to national law. And normally in these cases, that when one's looking at limitation periods, it very often is a debate about where, oh well, the claimant's not aware of its substantive rights, so it didn't take steps, and it comes along later and says, well, for some reason, the time limit shouldn't be applied to me. That's a case like Leeds City Council, for example, where the taxpayer says after the event some modification should be made to the time limit. This case is different. These are people who sought to assert their rights, and they use the procedures they use procedures that appear to be available. And what is happening is that because, and this is the application of the unduly extensive application of the declaratory theory, what is happening is the conforming interpretation is then being put up after the event to say, well, I'm terribly sorry, you've done the wrong thing. And the burden of my case is that that conclusion is not consistent with the principle of effective judicial protection. I was going to show the court Bellet again as another illustration. This is 1995, much longer established.
And so therefore plenty of time for the Court of Justice to have applied it.
Well, we are in somewhat unusual territory in this case, where with very long-running litigation, with many twists and turns, but where taxpayers.
Sorry, you must be talking about the present litigation, which seems to me to have nothing to do with it.
Yes.
Because what you're trying to establish at the moment
Yes.
is what the applicable general principles of EU law are. And you so far referred us to one decision of the Strasbourg Court in May 2020, which you accept has never been applied by the Court of Justice pre-Brexit. Now you're going to refer us to a second one, which is much older, and therefore one might have thought might be more germane, because at least temporally speaking, there would have been an opportunity for the Court of Justice to have applied it prior to the 31st December 2020. I don't see what the facts of present litigation have got to do with that question.
I'm sorry, I understand. They don't, and I'm sorry.
So, are you able to point us to a decision of the Court of Justice applying Bellet?
No.
Right.
But what I do point the court to is the point that the EU principles, they do take inspiration from the Strasbourg case law, and they should not be providing any protection that is less than that which is recognised in the Strasbourg case law.
One of the difficulties I have, Mr. Brummer, is that I can't help thinking there's an element of circularity here. You said in answer to an earlier question of mine, well, this is a retrospective change.
Yes.
But it's a function of the EU law declaratory theory. They haven't used the label retrospective. It's not like the sort of, oh, let's change the procedural laws in a particular jurisdiction in 2020 with effect from 2010.
No,
It's just an application of EU law. So my question or concern is that if you're right, your argument would seem to have really significant practical consequences, that every time the CJEU recognises the existence of a right or a discrimination, for example, that national authorities or legal systems, when they apply that, have to go further than just recognise the right and effectively mould other provisions to put claimants in the position that they would have been if they'd known the position at day one?
Well, it very much depends on the particular facts, because what the principles we're looking at would not help, and they didn't help a litigant like Leeds City Council. So Leeds City Council didn't know that its VAT supplies were non-business, but it was able to make its claims, but only by reference to the usual limitation periods, and because limitation period had been prospectively introduced, it wasn't able. There was a part of its claim that was time barred. I'm dealing very specifically in this case with litigants who took steps at a time that the law was uncertain, with the specific objective of vindicating their EU law rights. And what we're looking at is the impact of the conforming interpretation on litigants who've taken those steps. There isn't, in my submission, some more general knock-on effect for people who haven't done anything and who are now outside the normal time periods. What we'll see when we look at a case called Impact is the Court of Justice recognises that conforming interpretation has to be applied, taking into account other general principles of union law, and the one that they refer to in particular is legal certainty. And it can't be right in my submission that a litigant who takes what is an ostensibly available remedy is then later told, well, because of the retroactive application of the conforming interpretation, that step that you took didn't actually have any validity at all. That's the very particular circumstance we're looking at.
Particular to statutory regimes, because I don't recall you arguing this point on the pleadings issue in Access and Life, where in broad terms a very similar point could be made. You know, at the time those pleadings that we were looking at were put forward, as you eloquently explained to us at the time, the EU law position was uncertain. Now, I know you don't agree with the result that the court came to in that case, but I don't recall this line of argument, so I just wanted to understand whether your argument is specific to how we apply statutory procedural mechanisms.
So the point here is that take the paragraph 51 on the law as it stood in, say, 2009. It was perfectly reasonable to think that that was a good paragraph 51. Effective legal protection wasn't argued out in quite this way in AXA, probably because it was being assumed that the ouster was valid, and that's why there was a lot of focus on how things stood as at 1 April 2010.
I don't think that meets my point, Mr. Governor, which is the pleadings which were put in before 2010. You were just there was a straightforward argument about the construction of those pleadings.
That's right.
And whether they did or didn't encompass the relevant claim. I do not recall you arguing that we should be helped on our way, as it were, to construing those by principles of EU law of the kind you're raising now.
And I think that's
so my specific
I think that's right.
It may be that that wasn't argued for all sorts of different reasons, but what I'm really getting at is trying to understand your argument in the context of this case and asking whether it's a point you're making about the way we should approach the statutory procedural regime.
Well, I think it's an aspect of how one deals with the conforming interpretation, and the statutory procedural regime is very closely tied up with the substantive provision giving the credit in section 790.
So what statement of principle in Belay do you say is this?
Paragraph 36, Lord.
So again, this is all about Article 6,
Yes, it
paragraph
is.
1 of the Convention. Effective right of access to the court.
Yes. Which in my submission, that right of access is one of the things that is being covered by the EU law right to effective judicial protection. And you can see why the breach was held to exist from the final subparagraph in paragraph 37. And that's why he didn't have a practical effective right of access to the court, as is found in paragraph 38. Can I show the court, please, what I say is the same line of thinking, but this time in the Luxembourg court? And this is Viciano, which is in Authorities Volume 5, tab 60, and this is 2009. Starts at page 1698 of the Authorities. Just for you to note, this case is summarised by the Upper Tribunal in 88 to 89 in their decision. I'm sorry, I've given you it's 68 to 69. I've given myself a bad reference. But sticking with Viciano, the facts are a little bit involved. Perhaps I can just summarise them and then show you the provisions of Italian law. We're dealing, Mr. Viciano, he was an employee and his employer had gone into liquidation. He submitted an application for compensation by a particular Italian guarantee fund. The fund paid him a lesser amount than was due. There were some judgments of the Court of Justice. What Mr. Viciano did was he made an application to the Italian court and said, I'd like the difference between what I've been awarded and what's due. And the fund said, you can't have that because your claim's out of time because a 1-year limitation period applied. And the claim was a separate claim, and you can get that out of paragraph 22, that last point, in the court's judgment, page 1711. And what I've just said tries to summarise 18 to 21 in the judgment. One of the problems is the problem that's recorded in paragraph 23, and that's that Italian law had been inconsistent as to the correct classification of the claim, so whether it was a claim against the employer or a social security claim. And that led to the questions that are set out in paragraph 24, and the first was whether it was permissible to reclassify the claim. And then the third question concerns the limitation period, particularly in the light of equivalence and effectiveness.
Yeah, and the reasoning was that the national law fixed a limitation period but didn't determine when it started to run. And
Yes.
that, in combination with the way in which the Court di Cassazione had treated the case, gave rise to legal uncertainty, which might constitute a breach of the principle of effectiveness if it explained the late lodging of the application.
Yes, indeed. 46 in particular, 47, 48, and then the last
So-
point in 49.
Is it your case that in the present case there was legal uncertainty which might explain the late lodging of your client's applications?
There's a late lodging of a credit claim if a credit claim needed to be made and has not yet been made. Because I do say, and this is turning to this case, the UK provisions, they expressly told taxpayers there wasn't any credit other than the withholding tax credit. That's particularly section 790 sub 5 sub C. And no one could know prior to 2012 that a foreign nominal rate credit was required. Still less could anyone know that section 790 would be the means of vindicating the EU law right to equivalent treatment. And so until the UK provisions are subjected to the conforming interpretation, there is no clarity as to the remedy that should be pursued. And I do say that on the Upper Tribunal's analysis, what's happening here is a retroactive imposition of a requirement to claim a credit, and that requirement would not have been apparent when many of these claims were being made. So you've got taxpayers who take the steps which appeared to be the relevant steps, using the mechanisms ostensibly available to them. And I do seek to draw an analogy with the application of the wider principles that we see in cases like Gil San Juan and Bele, but also the sort of thinking that one sees in Viciano as to how it is that there may be legal uncertainty. In the skeleton.
Can I ask you this question? Is there any case law of the Court of Justice that you're aware of which addresses this question of whether the retrospective interpretation of legislation by the Court of Justice is capable of giving rise to legal uncertainty?
Yes, there's one case, Lord, its impact.
Right, that sounds like it might be helpful. So, shall we have a look at that?
Lord, yes. Let me just find where I've got my reference. Impact is Authorities Volume 5. And I think it's at tab 59. And the judgment starts at 1654. And the nature of the dispute, you can see at paragraph 2, it's all about pay and conditions for Irish civil servants, and it's all quite lengthy and complicated. The statement of principle, what should I say? Can I perhaps should do this slightly more slowly? The statement of principle comes in answer to question 4. And question 4 is set out in paragraph 36. And there are some issues about the extent to which in the domestic law provisions can be interpreted with retrospective effect.
Yeah, so the court's understanding of the question is set out in paragraph 93.
Correct.
Whether the court's understanding is that the question is whether the national court is under an obligation, by virtue of its obligation to interpret domestic law in conformity with community law, to give the 2003 Act retrospective effect to the date by which that directive should have been transposed. So that's a question about the national court's obligation to construe legislation in conformity with EU law. And I apologise if my question wasn't clear, but the question I was asking about was legal certainty, uncertainty created by the Court of Justice's own retrospective interpretations. Not quite the same thing.
Well, can I finish the thought, and then we can perhaps look at whether I need to think further about the answer to your questions. Paragraph 100 was particularly what I had in mind, because that does say that the obligation, it so happens this is all to do with referring to the content of a directive, but nothing can turn on that, because interpreting a directive is just an aspect of the leasing principle. It's got to be the same if you're looking at the treaty.
Yeah, and then in 101, they say you've got to interpret in accordance with community law, and they cite FIFA, which of course is leasing.
Yes. But the point I was going to emphasise was that obligation to interpret pursuant to leasing, that's limited by general principles of law, and it's particularly those of legal certainty.
But the answer comes at 104. National court hearing a claim based on infringement of national legislation transposed directive is required under community law to give that provision retrospective effect.
Well, it says only if that national legislation includes an indication of that nature capable of giving the provision retrospective effect.
Yeah, so you can't interpret it contra lege, but subject to that, your leasing obligation is to do so.
Well, but going back to paragraph 100, my lord, with sensitivity to general principles of law. And it's only in particular.
All right, but I'm sorry. I'm sorry. I'm obviously failing to make myself clear.
I'm sorry, my lord.
The issue in the case, in the impact case, as I understand it, was the extent to which the EU law obligation of compliant interpretation forced the national court to adopt interpretation with retrospective effect. But that's not our question, because we know the answer to that in our case, which is we are obliged to interpret the tax legislation consistent with EU law, and it's been decided how to do it, and,
yes,
and it's accepted it does have retrospective effect.
Yes.
The question is whether we gain any understanding from the Court of Justice as to this question of legal uncertainty as a result of such retrospective interpretation.
Yes, and at the moment the best I can do is to say that there is a recognition in paragraph 100 that the general principles may limit that obligation.
But that's a reason not to do it. Whereas here, we have done it.
My lord, that's where I was parting company with my Lady Justice Falk this morning in saying that it's wrong to approach this case on the basis that Prudential's happened, the conforming interpretation is established, that's the end of it. We have to look at these particular claims and ask, in the context of this case, does any further work need to be done in order to comply with the general principles of EU? That's the burden of the submission at this stage.
You are relying on the substantive rights to vindicate. You are saying we want 790 to have this conforming interpretation. We just want some help, if you like, in glossing,
Sorry?
in overlooking what might otherwise be a procedural issue.
It's certainly
with the way we formulated our claim.
it's certainly right that in quantifying the claims, there's no difference between the effect of the claims that were actually made and what would have been the provisions if letters had been sent in saying, please give me credit under section 790, and by the way, that reduces the amount of UK tax chargeable. There is also an oddity in that it's actually quite hard to see if you just make a credit claim how that gets you your money back. But I'll come back to that under issue 2. But it's right that if one's looking in what substantive ways did the UK provisions fail to comply with EU law, the Court of Justice has given us the answer. What I'm saying is that one needs to look more closely at what is the knock-on effect when it comes to this procedural matter of whether in these particular cases the steps that were taken prior to the conforming interpretation being established had any effect or not. And I do say that impact illustrates the need for the conforming interpretation to show at the very least sensitivity to other general principles of law. I was embarking on saying that in the skeleton we categorise sort of four errors that the Upper Tribunal made. The first in my submission being the nature of conforming interpretation as a response to a prima facie breach of EU law. Because when we looked at Prudential High Court, one can see that what that conforming interpretation was doing, it was identifying the extent of the unlawfulness of the UK's dividend taxation regime. What that conditioned was the extent to which unlawful tax had been charged and therefore how much tax could be got back. So we were working out how much tax had been charged unlawfully. And that, of course, didn't raise any issues of legal certainty. That was the conforming interpretation being deployed in a context where we need to work out how much tax has been overcharged and therefore how much tax has been paid by mistake. And my complaint in this case is that what is now happening is that it's being said without there having been any consideration of prior statutory claims. Well, statutory interpretation simply is what it is. The statute can only have one meaning. And so we simply have to look at whether you've been, if you like, lucky or unlucky. Were you a fortunate litigant who brought a common law claim? Or were you a fortunate litigant who by happenstance gets a remedy because you amended your return in time onto an exemption basis? That's issue 1, which is common ground. The reasons why there's relief aren't common ground, but under issue 1, the revenue says, well, the exemption amendment doesn't work, so we'll, in our closure notice, change the status of the dividend income to taxable, but we're prepared to accept that that triggers an entitlement to make a new claim under section 806 sub 2. But really that is just happenstance rather than anything else. What we have in this case, and it's particularly true when one looks at the paragraph 51 claims, is that taxpayers who took what at the time would have appeared to be reasonable steps to enforce their rights, they're now told, well, the conforming interpretation is retroactive and that's the end of it. You've done the wrong thing and your claim is invalid. And in my submission, in my submission, the vice that underlies the Upper Tribunal's decision is that it really takes out of context the conforming interpretation that was established in Prudential. It doesn't look at the purpose for which that conforming interpretation was being articulated, and it doesn't properly take into account the other issues that arise when a conforming interpretation might otherwise trespass on steps that have previously been taken to vindicate EU law rights. And I suppose drawing the threads together from what we say in the skeleton, what I'm saying is that it's forgetting that a conforming interpretation is a response to a prima facie breach of EU law. I fully accept that what is happening here is that this is all part of the domestic legislation having effect, subject to the requirements of EU law. But one can't lose sight of the fact that the way in which this has come about is that there is a prima facie breach, and what we're supposed to be doing, and you can see this in my leasing itself, is that the conforming interpretation is an aspect of remedy. It is an aspect of protecting the taxpayers' EU law rights. And perhaps I should just show the court one passage in the authorities that makes that point for me. This is in the IDT case in this court, in Authorities tab 23, which is going to be in volume 1. And I only need a short passage, which is actually this court quoting from Pfeiffer, which my Lord Justice Arnold mentioned a few minutes ago.
I've got tab 23. Did you give us a page?
I'm sorry, I hadn't yet.
Page number
The
with
judgment starts at 223,
Yeah.
and the quotation from Pfeiffer starts in paragraph 80 at page 245. And it looks as if something's gone slightly wrong with the paragraph numbering in the quotation, because I think it should be 111 rather than TIL. But nothing turns on there. And I simply observe that the discussion of conforming construction, which comes in 112 and following, it's all prefaced by the overriding observation that the context of this is that it's the responsibility of the national courts, in particular, to provide the legal protection which individuals derive from the rules of community law and to ensure that those rules are fully effective. So my leasing is actually an aspect of that requirement of effective judicial protection. And it's in that sense that I'm submitting that conforming interpretation is properly regarded as an aspect of the remedy. I can see that one can go slightly around in circles and start saying, well, it's a prima facie breach. The interpretation means there is no breach, so you need no remedy. But that's an artificial way of looking at the position in my submission. The reality of this is we have this system where domestic law is enacted, but that is to take effect subject to the requirements of the 1972 Act. And one of the things to which the domestic law is subject is the ability to have a conforming interpretation to enforce EU law rights. And one mustn't lose sight of the fact that it's only when there's a prima facie breach of EU law that one gets into conforming interpretation in the first place. And that's one of the reasons why I do say that this use of conforming interpretation, which is to say the conforming interpretation is done and settled, it now just applies retroactively, and we're just going to ask in a very narrow way, does the step that was taken in the past actually match up to the conforming interpretation that's been settled in a different context and for a different purpose? That is not the right approach in my submission. In particular, it doesn't properly give effective judicial protection, because it doesn't engage with the fact that these claimants were taking the steps which ostensibly appear to be available to them at the time. So that was the first error. The second error is the error we point to in paragraph 28 in the skeleton, which is the Upper Tribunal's conclusion in its paragraphs 129 to 130, that the problem in the present case is really just some unfortunate consequence of the substantive uncertainty of EU law. So the submission which the Upper Tribunal accepted was that the difficulties in these cases, they'd been caused by EU law itself, including my leasing, and that was a reason for distinguishing, in particular, the overriding principles upon which I was relying. And in my submission, that was an error of law, and for the four reasons that are set out in paragraph 28 in the skeleton, the first of which is that there's no relevant distinction between EU law and UK law in these circumstances, because ultimately what we're dealing with is rights given effect in UK law through Section 2 of the 1972 Act. So it's all norms that form part of the UK's legal order. That's the first point. The second point is that in my submission, the Upper Tribunal went wrong insofar as it thought that EU law always requires the my leasing principle to be applied retrospectively. Very often that may be the case, but it's not in my submission always the case, and it isn't the position.
I don't understand how that point assists you in circumstances where, as we've already established, in the present case, the question of a prospective only interpretation was expressly raised with the Court of Justice on the first reference, and the Court of Justice said no. And so as a matter of EU law, the UK courts were bound, insofar as it was possible without going contra legem, to interpret their domestic legislation consistently with EU law, and that's what they did.
Well, that's right, and insofar as one's looking at the substance, so substantively, did UK law comply with EU law? It's of course essential that the ECJ's ruling is retrospective. So if the request for temporal limitation had succeeded, my client's claims couldn't get off the ground for periods before a date in 2006 or 2007. So of course it's right that the application of EU law has to be retrospective if we're to claim for prior periods. That's right. It's a different question, however, whether the conforming interpretation can be applied in a way which undermines the steps that were taken prior to the conforming interpretation being established. So one needs to distinguish the different ways in which retrospectivity might be felt in my submission. Because what one's looking at here, and this is the consequence of what the Upper Tribunal has done, is that the my leasing principle is being applied so that the procedural provisions that are then applied are defeating claims that were brought to vindicate the very rights that have been recognised by the Court of Justice. And that is out of sync in my submission with the purpose of, and what the my leasing principle is all about. The purpose is to ensure that where possible domestic legislation is construed to give proper effect to a litigant's EU law rights. It shouldn't be being used to undermine those EU law rights. And that was why I showed you that paragraph in paragraph 111 of FIFO, which was cited by Lady Justice Arnold in paragraph 80 of IDT. So it's wrong in my submission to see this as some sort of abstract exercise. Let's look at what might have complied with EU law. Now, in the light of that, let's look separately at who's been lucky enough to make the right sort of claim. And that's why I prayed and aid the example. Well, suppose the very first case had been a paragraph 51 claim. The court would have had to look carefully at whether the effect of the conforming interpretation could really be, as the Upper Tribunal has found in this case, that actually, although the breach of EU law was established, the conclusion was that there was no relief at all. And that would, in my submission, be a very surprising result. And that's why I emphasise, particularly paragraph, I think it was 106, last sentence in Prudential High Court, and paragraph 77 of Prudential Court of Appeal, that in those cases, the difference between conforming interpretation and disapplication made no difference. In these cases, it makes all the difference in the world. And that was why, in answer to my Lord Justice Arnold's question, I was relying on paragraph 100 in impact, because that does at least illustrate that there are wider principles at play when it comes to conforming interpretation. So they were the first two errors, and then the third error is to say that there's nothing in any of the authorities to suggest that when it comes to effective legal protection, that the source of the uncertainty is relevant, in the sense of, is the uncertainty caused by domestic law or by EU law, nor is there any reason of principle why it should be relevant. And actually, if one looks at Viciano, one can see that the uncertainty that was created in that case, which the Court of Justice, I fully accept there's no final finding, it's sent back to the National Court to decide whether on the facts there is a breach. But the uncertainty in that case appears to have been something of a combination of what the EU law rights were and what it was that Italian law was providing. So that was, in my submission, a second general error that the Upper Tribunal made. The third general error and this is picking up paragraph 29 of the skeleton, is that the premise of the Upper Tribunal's decision is that there needed to be a claim for a tax credit. And in my submission, that's wrong, both as a matter of EU law, because it's a breach of the principle of effectiveness, and it's also wrong as a matter of domestic law because it wrongly characterises the mistake that has been made. And so can I deal first with the EU law aspect? So this is going to involve looking at Metal-Gesellschaft, and then can I look at the domestic law, and that's going to require me to look at DMG and at Prudential. So Metal-Gesellschaft is in Authorities Volume 5. And it's tab 57, starting at page 1580. this, of course, as the court will know, is all about ACT and group income elections, as indeed is Deutsche Morgen Grenfell. But the principle that's recognised in my submission applies equally in the context of double taxation relief in section 790. In my submission, what we'll get out of Mettler-Gesellschaft is a proposition that it's not open to the tax authority to argue that a prior claim to tax relief is needed before a claim to recover overpaid tax can be maintained. So we know, and this is sort of trying to avoid dealing with a whole host of the discussion in Mettler-Gesellschaft, we know, and it's found here, that the UK provisions, they breached EU law by precluding the group income election in cross-border situations. So if you had an overseas parent, the UK provisions didn't permit the group income election to be made, and it's the group income election that would have turned off the ACT charge. And at this stage, there are claims both in restitution and in damages. And what we'll see is that the court's answer to the question that I'm interested in deals both with the claims for reimbursement as well as the claims for reparation. So this isn't something that's sort of particular to the damages claims. The questions are set out in paragraph 33 of the judgment, which starts at the bottom of page 1614. And so you can see question 1, whether it was essentially consistent with EU law to limit the group income election to UK resident parents. Question 2, if there was a breach of EU law, was there a restitutionary right to recover interest, or could that only be claimed by way of an action for damages? And the problem there, of course, was that it was only time values that had issue. 3 and 4 were dealing with tax treaties, and I don't need to worry about that. And what's found is it's not consistent with EU law to limit the group income election in that way, and there has to be a right to recover interest. And then it's against the background of those findings that the court has to deal with question 5, which is just above paragraph 34. And the question is asked in relation to all of the claims, so restitution, tax credit, or damages. Was there an entitlement to plead in answer for the UK? Claimants are not entitled to recover, read short, despite the terms of the national statute which prevented them from doing so, because as a matter of national law, they ought to have made a group income election or claimed tax credit and appealed to the commissioners and if necessary courts, essentially relying on the direct effect of EU law. So that's the question that's being posed. And then that question is addressed by the court at paragraph 98 and following, which you see at the bottom of page 1625.
So the claimants couldn't be faulted for failure to indicate their intention to make a group income election because it wasn't allowed under national legislation. It would have been thrown out by the inspector.
Exactly right. And it's true that the UK government's submission that's focused on damages claim, you see that in paragraph 99, but the court's analysis is not limited in that way. And the passages that make good the summary that my Lord Justice Arnold has just set out, it's really what 103.
And so the court characterises the UK as blaming the claimants for lack of diligence and not availing themselves of remedies other than those which they actually took to challenge compatibility,
Yes.
and thus criticising the claimants for complying with national legislation.
Yes, that's 105. And then they say that if that were an answer, 106, that would render impossible or excessively difficult the vindication of EU law rights, and that's both the claims for restitution or compensation. You can see in line 3. This does matter because, and we'll see this when we look at the domestic analysis in DMG, and it's particularly important for the paragraph 51 claims. If you just looked at the domestic provisions on their own, without regard to EU law, if there was no group income election, then the ACT was due, and that's an observation that we'll see Lord Hope make in DMG. And what the Court of Justice is saying is, well, no, that in EU law terms, that is not an answer, because for that plea to be accepted would infringe the principle of effectiveness. So it wasn't an answer to the restitution claims that because there was no group income election, then looking at the UK tax provisions in isolation, the ACT had fallen due. Now, the Upper Tribunal, this is paragraph 134 of its judgment, it distinguished Metal-Gesellschaft. They said, well, that was all about failure to act diligently by not making a group income election. This case is concerned with a different question, whether the taxpayer had an effective remedy in December 2009. But in my submission, that's not a valid basis for distinction. What the Upper Tribunal is actually doing is saying the claim that needed to be made is a Section 790 claim, but that's reviving the very position as a matter of principle that was rejected in Metal-Gesellschaft, because what that would require the taxpayer to do is to make a claim for the very tax advantage which national law on its face denies to them. Because if you look at what the Upper Tribunal is saying, they're saying you needed to claim under Section 790. But if that's right...
So it's my fault, I'm sure I'm not following that, because the problem in Metal-Gesellschaft was that the claimants complied with national tax law, but they challenged its compatibility. And then the question was, well, what was the remedy to which they were entitled? And what the court said was, well, you can't use the fact that in the meantime they comply with national law to deny them their remedy under community law,
yes.
EU law subsequently. But that's not what's happening in the present case, because there's not a denial of a remedy for the breach of community law. The remedy lies in a restitutionary claim.
Well, no, one needs to take this in stages, because the reason and one will get this perhaps a little bit more clearly when we look at DMG in the domestic context. But if you go back to the question in sub 5, one of the things that's being contemplated is, well, they should just have made the election and appealed. And I'm observing that under the domestic statutory provisions, the consequence of not making the election is that if you look at the statutory provisions and you don't pay attention to EU law, then the ACT was due. That must be right. And I'm drawing an analogy between that circumstance and this case, because what the revenue says, and the Upper Tribunal agrees, is, well, unless and until there's a claim to credit, the D5 tax is chargeable and is due. And my submission is that analysis, what that would require is the taxpayer to seek the very advantage that's denied to them in national law. That's why I emphasised up front that Section 790 on its face expressly denied the credit for tax paid, and it only gave the withholding tax credit.
But that may be the reason why this wouldn't be a good answer to a restitution claim.
Yes. And I'm going to come on because I need to look at DMG
Okay, where do we
And-
find
and-
DMG?
and look at whether there is a difference between a restitution claim and, relevantly in this case, a paragraph 51 claim. Because what DMG is, of course, not addressing statutory claims. The point that I'll be making is that the nature of the mistake can't be any different according to whether what's at issue is a restitution claim or a paragraph 51 claim. What we get from DMG, and the members of the House of Lords get there in slightly different ways. I should preface my submissions with that observation. But one way or another, what we get is that even though under the UK statutory provisions, ACT was due unless a group income election had been made, even though no group income election had been made, the breach of EU law meant there was still unduly levied tax paid by mistake. And so DMG, I can put away volume 5, and I need DMG in volume 1. At 25, starting at page 274. Just before I get to the point that I need, I should just, to be clear, say, of course, the ruling on what one might call the date of constructive discovery in section 32(1)(c) of the Limitation Act, that's overruled in FI Supreme Court 2, but the passages I'm going to show the court now, they're not affected by that. So the analysis of what counts as a mistake in DMG, that is still good. Please can I pick this up in the judgment, first of all, of Lord Hoffman, because there's a summary of the statutory background is in paragraphs 3 and 4, and just put short, ACT was due on the payment of a dividend, but the liability to pay ACT was subject to an exception where the group income election had been made. And we'll see that addressed in rather more detail by Lord Hope in his speech. But before I get to that, Lord Hoffman addresses the nature of the mistake in two places, paragraph 23 and then paragraph 32. Could I perhaps just ask the court please to read paragraph 23? So that's the point about the retrospective nature of judicial decision making, and it's answering the objection that had been made by Professor Birks and Sir Jack Beatson about whether there was a mistake at all. And that's Lord Hoffman's analysis as to why there's a mistake. And then in 32, it's his, if you like, his first footnote. He says 2 footnotes on the question of mistake at the bottom of page 288. And here in 32, Lord Hoffman explains what he says the mistake was. Perhaps I just ask the court to read that paragraph. and this is really to do with the stage, if you like, at which the mistake is made, because Mr. Justice Park had said, well, the mistake isn't about whether ACT was payable. There'd been no election, therefore it was payable. The mistake was about whether you were allowed to elect or not. But the Court of Appeal had said, no, the mistake was about whether DMG was liable for ACT, and that's the approach Lord Hoffman endorses, and that's because the election provisions were purely machinery, which DMG would undoubtedly have used, by which it could enforce its right to exemption from liability. And that point raised in paragraph 32, it's discussed in rather more detail by Lord Hope, and then it's also touched on by Lord Walker, and Lord Hope takes a rather different approach. I can put his analysis up at paragraph 57 under a heading, the mistake issue. So the starting point is that DMG needs to show it had made a mistake, and the point that was being taken by the revenue was that there'd been no mistake because the tax was due and payable when DMG paid it because it hadn't made a group income election. Just in parentheses, and I can't really assist with this, it seems that Lord Hope's understanding of the issues was rather different from Lord Hoffman, because if one looks back at paragraph 24, Lord Hoffman says that it had been accepted that earlier payments had been made by mistake, but I don't think anything turns on that for the purposes of the debate we're having. I don't think I can really help as to what was really going on. Lord Hoffman was right. Is that Malone Friend says he thinks Lord Hoffman was right and Malone Friend was there, and I certainly wasn't. But anyway, it gets decided. So paragraph 58, and this really is summarising the effect of the statutory provisions set out paragraph 3 and 4. The only way the UK company can avoid the liability to ACT is on making the group income election. And so, as Lord Hope records, if the correct approach is to look only at the system laid down by the statute, it's plain that because there was no election, there was no mistake. And his approach is to say, well, that overlooks the principle upon which the claim for restitution recognised in Kleinwort Benson is founded, and that's unjust enrichment. He explains what that involves. It's unjust for the defendant to retain the money paid under a mistake, and the injustice arises because the payor didn't intend the recipient to receive the payment. And then he says, beside the letter F, that the claimant must prove he'd acted under a mistake, but the stage when he made the mistake doesn't matter, so long as it can be said if he'd known of the true state of the facts of the law at the time of the payment, he wouldn't have made it. And as he says, wrong turning half along the journey, that would count just as much. And then in 60, he cites Barclays Bank and Sims, and refers to what Professor Burrows had said in his textbook. And in paragraph 61, that deals with evidence that had been given by DMG's witness, so Mr. Thomason. It was paid because the relevant provisions of ICTA required it to be paid, and he thought he was bound to act in accordance with the law. And then in paragraph 62, again, there's reference to what Mr. Justice Park had found, and then what the Court of Appeal had said. And between E and F, Your Lordship will see Lord Hope, in contrast to Lord Hoffman, preferring what Mr. Justice Park had said. So in his view, it was the mistaken belief that group relief couldn't be
So which was the majority view?
Well, I'm going to come on to that because it's quite hard to identify a majority, my lord, because it's there's a 3-2 split. And of the three, Lord Hoffman and Lord Walker prefer the approach of the Court of Appeal, and Lord Hope prefers the approach of Mr. Justice Park, which makes it rather difficult to identify a majority.
Lord Brown agrees with.
Maybe we'll need to look at Lord Brown as well, because I think Lord Scott had said it was on the damages claim anyway.
He agrees with them all.
Yes, Lord Brown agrees with them all. So I'm not sure that any of that gets us out of the difficulty of in relation to identifying the majority. But just sticking with the principle.
All right, but which speech in your submission represents the law?
In my submission, it's Lord Hoffman and Lord Walker. And can I just show you what Lord Walker said? There's paragraphs 143 and 144. So Lord Walker, para 143 is at page 325. And you can see his summary of the estate by the letter E in 143. And can I just deal with what happened rather more close to home in this context, in Prudential, in terms of what the mistake was, because that's in Prudential High Court. And that is Authorities Volume 3, tab 30. And can I just sort of situate this first of all? I've said already what the High Court was adjudicating on here was the High Court claims for restitution of unduly levied tax. I'd like to show the court what Lord Launcelot Henderson had to say about the statutory claims at the end of the judgment. But before I do that, I just want to deal with the nature of the mistake. What's important for my purposes is that Prudential High Court is not saying that the basis of the claims was that the taxpayer had some entitlement to make claims for additional double taxation relief. That there was certainly no, or at least there was certainly no requirement in order to make claims that Prudential needed to make claims for additional double taxation relief. I think I'm right in saying that in the Prudential High Court judgment, there isn't any discussion of what statutory claims the Prudential had actually made. But the first tier in this case has made findings about that. That is FTT 110 in this case. And this was accepting evidence of Mr. Anderson that the relevant claims were claims under paragraph 51.
But it wouldn't have been relevant.
No, it would have been, my lady, because it, well, your ladyship says, well, because it's restitution, but there would have been no, if there was a requirement, first of all, to claim double taxation relief.
Yeah, indeed, but that's all in the context of the common law.
Yes, indeed, lady. But my submission is, when one looks at a paragraph 51 claim, there is no principle that allows one to say that there is a requirement first, for example, to claim the DTR in order to make a paragraph 51 claim.
Okay, so
That's the point.
so
That's where
you
the Upper
say
Tribunal went wrong.
that this goes to a much more quite a fundamental.
Yes, it does.
You say that you can make a mistake for para 51 purposes in circumstances where you haven't made a claim, and you can claim under paragraph 51 effectively as if you had made a claim for a particular amount.
I don't need to go that far, my lady. What I'll be saying, is that the mistake was believing that the UK provisions were lawful when in fact they were not. And the claim is for the relief that would have been available if the provisions had complied. And that is taking the same approach that was taken in the context of ACT and group income elections, and indeed, as we'll see, in the context of the restitution claims in Prudential, that take the group income election, it was pure machinery. That step would have been taken had it been known to be available. But the point in Prudential is there needs to be unlawfully levied tax paid by mistake. And if the Upper Tribunal were right in this case, then unless one can point to some principle that says, well, we analyse restitution claims differently to paragraph 51 claims, and I pause there and I say, where is that principle? Where does it come from? The mistake must be the same. In Prudential, there were no claims to double taxation relief, and there was held to be a mistake in Prudential, and there was held to be unduly levied tax without there being any mention of there needing to be a prior claim for double taxation relief. This was a matter of concession. I fully accept that. The revenue conceded that the mistake, and this was paragraph 163 sub C in Prudential.
That's Prudential High Court.
It is Prudential High Court, yes. And it's page 76.
Well, fine, but what puzzles me is how that's juridically relevant. I mean, as you point out, it's conceded by the revenue that the tax was in fact paid under an operative mistake. The mistake being that it was lawfully due and payable. Well, that the relevance of that juridically is clear in a common law claim.
Yes.
How is that juridically relevant to a paragraph 51 claim, where mistake is not an ingredient in the claim?
My lord, perhaps we should look at paragraph 51.
Right.
And paragraph 51, as it stood at the time that Standard Life made its claim, this is in volume 1, tab 11, page 154. And I'll deal with paragraph 51, then I need to say a bit more perhaps about Prudential and what's going on there. 51 sub 1 needs to be tax paid under an assessment, or tick, because that included a self-assessment. And the tax paid has to be excessive by reason of some mistake in a return. And the company's got to believe that that's the case. And then there are requirement, notice and writing given to the board, not more than 6 years, etc. No dispute about those. And then 2, on receiving the claim, the board's to inquire into the matter, give by way of repayment such relief in respect of the mistake as is reasonable and just. And then 3, no relief to be given under this paragraph. A is the practice generally prevailing defence. And then B is in respect of a mistake in a claim or election included in the return. So in both paragraph 51 and the common law claim, one has to identify a mistake.
Now, the mistake identified in the letter sent to HMRC was that we've treated our dividends as taxable in the return when they should have been treated as exempt. I think you may now prefer to characterise the mistake in a slightly different way.
You can see that if you're trying to marry this into what the law has ultimately been found to be, then the mistake, and there's a finding about this from the First-tier Tribunal. It's paragraph 123, which is core page 306. The finding is that the mistake in the return was that tax was paid on the basis that the statutory provisions were lawful when they were not.
Okay, but what if there's just, is there not an argument that there's a different approach? I mean, that's could be said to be a finding of law. It certainly must be open to this court to work out what the mistake was. But can we
That's an
just
evaluation.
bear with me, because the returns correctly treated the dividends as taxable. There was no mistake in terms of treating them, wrongly treating them as taxable.
Well, in my
Can you?
of course, I'm very sorry.
Pose the question. The letter that goes in claims we've made a mistake. We treated them as taxable when they should have been exempt. I think you're asking us to read mistake in a rather broader sense of saying, well, we didn't make a mistake in treating them as taxable, but we did make a mistake in failing to claim relief.
Well, my lady, I say that I don't need to go that far. If we go back to the letter.
Well, I'm not sure. Yes, okay, but you've got to meet the point I've just made and my other points, that the mistake asserted by the taxpayer in that letter is of a rather different nature. And one can see, going back, say, to core page 41, that when they refer, for example, to section 208, a section 208 solution is not endorsed in Prudential High Court. That's right. But what they are clearly doing, if you look at this letter as a whole, they're relying on their EU law rights. They refer to a particular UK provision, as it happens, it's 208, and they say that the effect is that all overseas source dividends should not be chargeable to UK corporation tax. And one also needs to bear in mind, if one looks at section 793 sub 1 of ICTA, the substantive effect, if you have a claim to credit, is actually exactly the same. To the extent you have a credit, the UK tax is not chargeable. That's what 793 sub 1 But it
sub
has
1
very
does.
different consequences. If you're getting credit for underlying tax, you have to gross up under 795. The income entry in the return is very different.
Yes. But we're in a world where we're told that the quantification of the claim doesn't stop there being a valid claim.
Yeah, so can I come back to the question I was asking it, which my thought was badly expressed. But if it's a common law claim and you establish that the money is paid under a mistake that it's lawfully due when it's not lawfully due, the precise nature of the legal mistake is immaterial to your claim for restitution. It is sufficient that it was not lawfully due. And my question, I think, is better phrased as this. Do you say that the same is true in paragraph 51? In other words, that paragraph 51 is wide enough, maybe this is what you say, I'm not sure, to cover any mistake of any nature as to lawfulness?
I do go that far, first of all, but can I also just say that in relation to the common law claim, I would just pause on the point about, well, it doesn't matter what form the mistake takes, because it is important in Prudential that on the revenues argument now, and this is what the Upper Tribunal has endorsed, it said, well, tax is lawfully due unless and until an appropriate claim for double taxation relief is made. Now, if that is right, it is very hard indeed to explain the outcome in Prudential, because Prudential had not made claims for DTR, and yet its common law claims succeeded. So Prudential was not a case where there had been claims for additional double taxation relief credits. Prudential said, give us our money back because the UK provisions did not correctly implement EU law.
So just to follow up on the question I was asking you, because I think it's implicit in the question that my lady was asking you, that at least one possible construction of paragraph 51 is the claim must relate to the mistake that's specified. Whereas I think on your construction, the claim does not have to relate to the mistake that's specified.
It's specified in the claim.
Any mistake will do, even if it's not the one specified.
Because if one looks at 51 sub 2, the procedure is that there's to be an inquiry into the matter. And the matter in my submission can't sensibly be restricted to the reason that's given for why the taxpayer thinks he's made a mistake. And then what we're trying to do is to give such relief in respect of the mistake as is reasonable and just.
Yes, but you also need to look at the words in respect of the mistake. So it seems to me you need to identify the mistake.
And what I'm saying is that ultimately the mistake in a case like this, you could have characterised in different ways at different points along the journey of the cases. And so, for example, at the time of High Court 1 and Court of Appeal 1, the focus is simply on the lawfulness of the Case 5 charge. And there would have been an assumption at that stage that if the charge was found to be unlawful, then no further work needed to be done. And given that uncertainty, it cannot be right in my submission to construe that concept of mistake in paragraph 51 as being restricted to the particular mistake that's identified in the letter of claim.
The mistake must refer back to.
Well, but in 51 sub 1 it just says some mistake.
So on this view of the legislation, the revenue is obliged to give relief, even if it's for a completely different mistake to that claimed.
It has to be such relief as is reasonable and just, and it has to be the matter that's being inquired into, and the matter here in my submission is the treatment of the dividend income. One can't say that this is some completely unrelated. It's not some completely unrelated exercise. It's not that they suddenly found there were some capital allowances available over somewhere else. It's nothing like that. What's being said against me is, well, we've inquired into the matter. We've found that actually the mechanism through which the unlawfulness is to be remedied is by recognising an entitlement to a credit. We don't deny that you would have been entitled to those credits. You've put in a computation which, as it happens, gives you exactly the same substantive outcome as if you'd claimed credits. And yet it's reasonable and just for us to say, oh, well, I'm terribly sorry. The strict legal position is this dividend income was taxable, therefore the tax charge was lawful unless and until you put in a credit claim, and you didn't make a credit claim. That's in circumstances where the effect of the document that's submitted is substantively identical. to what it would have been if Standard Life had said, with amazing prescience, we predict that in 2012 someone will recognise a nominal rate credit. Here's our computation of what the effect of dealing with nominal rate credits would be. It would have given you numerically the same answer.
So on this particular, I know you have an alternative argument that the letter should be construed as a claim to DTR, but on this particular formulation, you say, yes, it's a paragraph 51 claim.
Yes.
And do you, as I understand your argument, you rely on DMG and the sort of mere machinery type
I do.
points in DMG
I do.
to say, in assessing the para 51 claim, it doesn't matter that we didn't
Yes.
go to DTR.
I say it's unreal and artificial that in the statutory context, suddenly the machinery is all important. And the Upper Tribunal says, oh, well, and this was picking up what Lord Hope had said, Lord Hope, I suppose, supported by Lord Brown, that the jurisprudential basis of a common law mistake claim is different to a statutory claim. I'd respectfully submit that that can't be right. The reason that a statutory claim is given is because it is unjust for the revenue to retain that money. Section 33 long predates Woolwich. There's some discussion of that in FI Supreme Court, but it took an awful long time for the common law actually to recognise the ability to recover unduly levied charges under the Woolwich principle.
But are you saying, is this is because applying a sort of interpretation with domestic eyes to para 51, some of what you say is quite tricky, but you're really saying it's an aspect of conforming interpretation.
Well, that's one point, and the other point, Your Ladyship says that applying the interpretation through domestic eyes, one cannot lose sight of the context of this, which is that the UK provisions breached EU law. And what the taxpayers are clearly trying to do when you look at that letter that Standard Life sent in December 09 at court page 41 is they are trying to vindicate their EU law rights. That must be relevant to the construction of the letter, that's the factual context in which it's sent. And the other point that's made against me, and this was critical to the Upper Tribunal's decision, I should just deal with this briefly, is it said, oh well, 51 sub 3 sub B would apply because the mistake would be in a claim or election which is included in a return. And that in my submission can't be right if one characterises the mistake properly, because if the mistake is the mistake about the lawfulness of the UK provisions, we can't possibly be within 51 sub 3 sub B. And if one looks at this factually, there never was any claim for the foreign nominal rate. It's true if you look at the later iteration of paragraph 51. So this is the version that comes in with effect from 1 April 2010. 51 capital A 159 gives a series of defences, one of which is where the amount paid is excessive by reason of a mistake in a claim, but also a mistake consisting of failing to make a claim. So what the Upper Tribunal has actually done is anticipated the enactment of 51 capital A when it says that 51 sub 3 sub B would apply.
So do you, because I wasn't very clear from your skeleton whether you rely on that point. Do you rely on 51 3B just not applying because there has been a failure to make a claim?
I say that that's good enough for me to get home. I say I don't get.
It doesn't emerge clearly.
I'm very sorry if it doesn't. I say I don't get there because you can't get into 51 sub 3 sub B if you characterise the mistake properly, because the mistake is, as the FTT found, a mistake about the lawfulness of the provisions. And that's particularly in circumstances where a claim for additional DTR that would have been rejected if it had been made. But I do also say that you can't sensibly describe this as a mistake in a claim. I wonder if that might be a convenient moment. I'd assume the court would only intend to sit to 4:15 minutes.
Well, how are you doing time-wise? Because I observe you haven't even got onto any of the issues yet.
I'm going to be getting to the issues very soon.
Right.
But
So do you think you're still on track?
I'm more or less on track.
All right.
I mean, I'm very much in your lordship's hands. It may help tomorrow if the court were willing to listen to me for another 10 minutes, but I'm...
Well, if my lord and my lady can manage that, we could carry on for another 10 minutes, if you think that will help. Is that all right? Okay.
I'm very grateful. As I say, I've got no serious concerns.
All right. Well, let's do another 10 minutes now in the hope that will speed things up in the morning.
I'm very grateful. I was just going to deal with one other aspect of Prudential, which was what was to happen to the statutory claims. So Authorities tab, volume 3, tab 30, starting at page 712. And this is dealing with issue 12, page 806. And we're dealing 260, first agreed issue, how to deal with the open years. And
I'm sorry, I think I must be on the wrong page. Could you give me the
806,
reference
no.
again?
806, it's issue 12, paragraph 260.
Thank you.
First agreed issue, how to deal with the open years, and this was agreed. And you can see how it's going to be dealt with halfway through paragraph 262. By the letter H, there's going to be a ruling on all disputed issues of principle in the same proceedings. And then, so far as possible, matters are going to be resolved absent agreement through the statutory procedure, and that's in order to respect autologic principles. And then just for completeness, paragraph 263 there, now I'm going to abandon the argument that the statutory claims procedure under section 790 excluded the common law claims. And just two points about this. The first is that the First-tier Tribunal, they accepted Mr. Anderson's evidence, this is FTT 109 to 113, that the claims that Prudential had brought, they were paragraph 51 claims.
Sorry, where are you pointing to the reference to paragraph 51?
Well, it's if one reads 109 to 113 in the FTT.
109 to 113.
Yes. And the other point to make is that concession that's recorded in Prudential High Court Para 263, that was a development of the revenue's previous position. Because if I can just jump ahead and deal with the point that I make in paragraph 40 of the skeleton, in FII, the revenue had positively argued that a claim under section 33, so that's the predecessor to paragraph 51, and paragraph 51 is also mentioned, that they ousted common law claims to recover unduly levied defied tax. And that position was also reflected in the Revenue's business brief 3 June 2010, which is at the end of the supplementary bundle. Can I just deal with this very quickly? The point was argued out by the Revenue in FII High Court 1 and decided against them. That is paragraphs 432 and following in High Court 1, page 482 in the authorities. It's 432 to 437. And that decision was overturned by this court in 2010. And it's particularly paragraph 262 of FI Court of Appeal 1 in Authorities tab 27.
Sorry, which paragraph?
262. It's the discussion is from 248 to 262, but the conclusion is that section 33 is an exclusive remedy. So that is the law to which the Revenue were responding when they published the business brief in June 2010, because Court of Appeal 1 had been decided in February and then the amended judgment given in March 2010. That decision, of course, was overturned by the Supreme Court in Supreme Court 1, where section 33, para 51 are read as being non-exclusive. But what the Revenue does in 2010, and this is the burden of the business brief, which is at the end of the supplementary bundle. So it's not at the end. It's at
So the business brief is prior to the Supreme Court
It is,
decision.
and after the judgment of this court. So it reflects the law as set out by this court in FI Court of Appeal 1
which was subsequently held to be wrong.
in 2012. Yes, that's right. And what that does, it's a page. I wasn't proposing to take you through the detail. It's page 203 in the supplementary bundle. What that does is suggest that if there are claims that raise prevailing practice issues, then the Revenue is not going to advance against those para 51 claims, the prevailing practice defence. So as we say in the skeleton, it's an invitation, if you're going to make a statutory claim, to make a para 51 claim.
Sorry, can you explain to me what's the relevance of the business brief in our case? Because first of all, it proceeds, as you've just confirmed, upon the basis of an understanding of the law that was subsequently contradicted by the Supreme Court. Secondly, it's not admissible as an aid to the interpretation of legislation anyway. Thirdly, there's no argument in public law in this case.
No, okay. Well, what it does is it shows, well, we know what the Revenue's position was at the time that, take the Standard Life claim. At the time that was made in 2009, the Revenue had been arguing that para 51 was the right route, and they'd failed in front of Launcelot Henderson. They then later succeed, and they continue that position in their published guidance in 2010. It simply shows the continued uncertainty as to the available remedy. That's the relevance of it.
Right. Is that
I've
a
got
convenient
yes, I'm going to start next on Class 8, which I need to deal with, and then I've got some short points to make about domestic law, and then I'm turning to the issues I'm very grateful to the court for sitting later.
Very good. We'll resume at 10:30 in the morning.
HMRC is the debtor. They owe money to the claimants. I'm reading about the case. I was thinking HMRC are the debtors. It means they owe money to the claimants if they are the debtor and they are trying to. HMRC are billionaire when you think about that, guys. The HMRC is true. I've just realized they are billionaire because there are billions of funds. No, because from my understanding of the case, it's study tax law. So this is very interesting for me. Like the HMRC is refusing to pay money to the claimant. So the claimant is trying to enforce the law. Statement of case. Statement of case.
I mean, often these days they don't.
It's very, very
Yeah,
special.
the clerk said we could leave stuff in.
In the CPR, I tried to confirm, it should be big, but I think you should ask the judge, that's fine. Are you the usher or clerk, usually? Usher?
Yeah, exactly. Because I'm like, what is sensitive?
The decision is that the case document should be given to the public or the media.
Yeah.
So you don't follow the law?
There's no,
Just statement of case that explain the ins and out of the case, not like the case file, you know, it's just a quick summary of the case. I'll just show you, but it's better to ask before the. That's very interesting. Some private people, they have dividends and they want tax return on their dividend, and HMRC said no, right? Because it's simple, just being honest, what they are doing here is not a rocket science.
Yeah.
Actually, making a computer is much more complex than what they are speaking about in this court. And I think like even you as a non-lawyer can understand. Because if you listen to case every day.
Yeah. It's just most of us are law students anyways, it's just
Sorry? I'm not a law student.
Huh?
I'm not a law student.
Then?
I study, I research into taxation. To just show you the.
we're live streaming this one anyway, so
Yeah, that's why it's very public.
Yeah.
It's very public. I'm gonna watch actually on YouTube.
Yep.
I say like Supreme Court decision. Give me. Yeah, that's the CPR 5.6. So speaking statement of case and judgment and order that are made in public are public documents and are available from court records. UK Supreme Court widen the scope for non-party access to document field in English litigation. So, but I understand it's too late now. Usually it's better to ask before because.
before we'll be prepared, but now there's nothing made for me to give to you.
No, it's just to tell you because I might come back and ask them.
Yeah.
I already asked to the civil court. They was trying to say they don't have to give it, but it's the common answer. And also, I think it's important for me to tell you why I ask because sometimes the court wants to know. It's not to share it. It's just for my own analysis. So it's to understand the proceedings for myself because I know sometimes there is a, like reporting restriction.
Yeah.
And this is not my goal to report any case, It's just for me to understand the taxation law, which is very interesting, It's HMRC against.
Yeah.
And for me, it's quite a special case because I don't understand. It's like insurance and investment funds involved. So it's kind of a bit more complex, I guess, than a normal case. I was wondering, what does the insurance have to do inside the Because sometimes I think insurance, they have banking activity, banks and insurance, you know, they have some similar activities like investment, consulting, but yeah. So usually when people ask, you don't, because I went once to Court 73, it was live stream also,
Yeah.
and they gave it straight away. Actually, I was impressed because I never asked,
Yeah.
and the usher, he just came to me and said, oh, that's for you. I was like, oh, that's interesting. I'm not asking this document and you are giving it to me.
Yeah.
But sometimes I ask,
When was that? Do you know?
oh, more than I think 1 year ago, maybe,
Oh,
something like this.
Unless it's something.
But usually
active
they don't like to give it. I don't know why. I think it's I don't know their reasons, but yeah, it's kind of, yeah. Anyway, I need to go. I just wanted to show. Yeah, it says the document has to be accessible to non-party as of rights without the need for the non-party to make an application to the court and explain why give it access to the document will further the open justice principle. The consultation launched earlier this year to resume a HMRC meeting held on 7 June progress. The minutes state that this will allow the new transparency and open justice board created in April. Yeah. Yeah, at present, some documents, mainly court orders and statement of case, are available to non-party simply on request to the court, but obtaining most documents might require an application. Non-party who seek such document might include, for example, media representatives, parties related to disputes, or simply other individuals or business who might take an interest. Under the non-party will be able to obtain a skeleton argument, expert report, witness, and affidavit, even before these are used in a hearing, and even if they are never used. But yeah, so usually I think you might ask to the judge, and then the judge might give it, you know. It's just to understand the proceedings.
Yeah.
Is to say what's going on between two parties, because it's like this, you see on the here, it's kind of say little bits, appeal, validity of claim to foreign tax on overseas dividend income. This is pure business. No, but just because people don't realize, this is amazing. I used to go to UCL library. This building is empty, but this is like one of the best places to learn about business. These people, maybe they are millionaire or billionaire. They manage investment funds, insurance.